Hello there, my name is Ryan Galloway, and I'm going to talk to you about how to debate the Supreme Court on the water protections topic. So the first question about debating the court on any topic, it would be, what does the court do? And the Supreme Court actually doesn't hear very many cases in a given year. It only hears about 80 to 100 cases. So there are a select number of cases. A lot of cases get appealed to the court, but they don't take very many. And then when the Supreme Court hears a case, they hear oral arguments. And it's kind of like a debate. One side gets up and makes their case, the petitioner makes their case, and then the Supreme Court justices pepper them with questions. You would begin your oral argument, and then maybe 30 seconds into your oral argument, any one of the justices can ask a question. And then you're expected to respond to those questions. Then you might go back to your argument and another judge asks you questions, and they might ask questions that are different than another judge, or follow up on another judge, or try and contradict another judge, but you hear oral arguments. Then the Supreme Court releases its decisions usually in May or June, and that'll be relevant to why the Supreme Court can be effective against politics disadvantages, because the Supreme Court doesn't usually release its decision immediately. So you can argue that the plan will be released after whatever politics disadvantage there is. And then the decision is theoretically binding. And I say theoretically binding because while there is certainly the normal course of things is that other branches or the states will enforce the Supreme Court decision, the Supreme Court actually does not have any power to enforce its decisions. It's just that other branches of government respect the court, and then their decisions are respected and followed through upon. But when we talk about the courts on the negative, you'll see that that's not always the case, that Supreme Court decisions don't always get followed, especially by the states. So what is the Supreme Court? The Supreme Court is the highest court in the land, and it has ultimate authority over the law in the United States. And then there are 9 justices on the Supreme Court, and they're appointed for life. And you probably already know this from government or from civics classes, but the reason why Supreme Court justices are appointed for life is that theoretically they're supposed to be immune to politics. Unlike a member of Congress or a president who makes a decision and then they have to face re-election, they might not want to do certain things because those things would be unpopular and then they wouldn't get re-elected. Well, in theory at least, the Supreme Court is supposed to be able to do whatever it wants to do, whether or not it's popular or unpopular. And so, at least in theory, the Supreme Court can take unpopular actions to protect minorities in the United States, either racial minorities or gender minorities or sexual orientation minorities, etc., because then they don't have to face re-election for what they did. And that even if something is unpopular, at least theoretically they're supposed to be protected from that. So then you might ask, how does a case get to the Supreme Court? Well, we'll start at a lower level and then get appealed to the Supreme Court. And there are various places in which cases come from. A lot of them come from state Supreme Courts. So the justices might take a case from a state Supreme Court. So you might have heard like Miranda versus Arizona. That came from the Arizona Supreme Court to the United States Supreme Court, or it comes from federal district courts, where the United States might be a defendant, like United States versus Morrison might be a decision that the Supreme Court takes from a federal district court level. And then when the justices decide to take a case, they grant a writ of certiorari, which is the formal documentation that says we're going to take this case, bring it up to the Supreme Court, And 4 justices have to decide to take a case for it to come before the Supreme Court. That's called the rule of 4. So if 4 justices decide, hey, we want to take this case, then they will decide the case. So then this begs the question, well, what do courts have to do with debate? And one thing you might want to think about is, which agent of action do I want to do the plan through? And it's become kind of commonplace in debate to not specify your agent, but there may be benefits to specifying the Supreme Court. And one reason why is it helps versus popular disads, especially the politics disad, which I'll talk about in a second or two. It also allows you to claim advantages from doctrine, so Supreme Court precedents spill over to other areas, and I'll talk about more about this in a little bit. But as an example, probably one of the most popular Supreme Court cases in history, and one you've maybe heard of, is Brown versus Board of Education, which desegregated schools. But that led to desegregation of water fountains, desegregation of bathrooms, desegregation of lunch counters, desegregation of restaurants, desegregation of hotels and motels, etc., because the precedent that separate but equal was never allowed under the Constitution meant that it would spill over into other areas. It also allows you to claim modeling advantages. So other nations look to the Supreme Court. Our justice system has unique legitimacy on the international stage. Other people look at what we do and they will cite cases from our Supreme Court to make decisions. So other nations, especially developing nations, might encounter similar questions to the United States. They might encounter similar questions on questions of water policy, like who should get access to water, and then that would allow them to claim modeling advantages. Furthermore, if you know a lot about the courts, it will give you a knowledge advantage. So sometimes you're facing people that know a lot about politics or know a lot about economics, and you can have a knowledge advantage over them because you know more about the courts. So the first thing you may want to think about is the politics disadvantage. And the politics disadvantage will be very popular on this year's topic. One of the reasons why is because Biden is at least theoretically able to do a lot of things with his agenda. And so a lot of people are very excited to run politics disads again. And the first question is, do courts link to politics, or can you get an angle versus politics by going through the Supreme Court? Well, the first thing to think about is Biden doesn't push the plan if it's done through the Supreme Court. So arguably, if the plan's done for Congress, Biden has to spend political capital to get the plan passed. And if he has to spend political capital, he won't have political capital to spend in other areas. But if the Supreme Court does the plan, Biden doesn't push the plan at all. And it's not an executive order, so Biden wouldn't take the blame for the plan. The Supreme Court would take the blame for the plan. And so you could say, we don't really link to the politics disadvantage. You've got to have something specific to the Supreme Court to debate us on. Plus, the courts can shield the president. And what I mean is they can say, the Supreme Court made me do it. There are cards which say, the president can say, the devil made me do it. I didn't want to do this, but the Supreme Court said I had to, so I had to follow the Supreme Court because that's the way checks and balances work. And so when someone says, well, Biden has to follow through with the plan, Biden has the ability to say, hey, I didn't want to do this, but the Supreme Court made me. Something I mentioned on one of the previous slides is that courts frequently release their decisions in May or June. So let's say you're debating in September or October, and they run a politics disadvantage based on something that's on the docket that week. You can say, hey, the normal means for the way the court works is they will release the decision after your disadvantage. They won't release it until May or June, and we're debating in October. And therefore, there's no link to the politics disadvantage because of when the decision is released. Another reason you may want to claim a Supreme Court case or run a Supreme Court case is because of doctrine advantages. So courts rely upon precedent, and precedents will spill over. I mentioned this in the Brown v. Board of Education case, that you may make a decision about schools, but that will apply to other areas. And similarly, you may make a decision about water, but that will apply in other areas. You may say someone has the right to water, but then in the next case, the Supreme Court will say they have the right to a clean environment, which could lead to solving warming or something like that, because the precedent would spill over. One doctrine I'll briefly mention is called the Chevron doctrine, and a lot of people claim advantages from that. And the Chevron doctrine deals with whether or not Congress should bind itself to an agency decision. So the Environmental Protection Agency, or EPA, will be enforcing a lot of plans on this topic, and they have interpretations of certain things under the Clean Water Act. And the question will be, does Congress have to do what the EPA said, or can they come up with their own interpretation? And the way in which the Chevron doctrine gets influenced can apply to other areas that are very different than water. They can apply in the environment, they can apply to trade policy, they can apply to a lot of different areas. And arguably, Congress and executive orders don't solve that. So you can imagine that if you do your plan through the Supreme Court, a logical counterplan someone will run is through the Congress or through an executive order. But Congress and executive orders don't solve for those doctrines because they don't have influence over those doctrines. They don't have the ability to change what the Supreme Court does in another area. So you can claim spillover effects into areas that are different than the plan. You can also claim international modeling advantages. So other nations model the Supreme Court. The Supreme Court has unique symbolic effects, so the Supreme Court's given some very important decisions that the rest of the world has looked at. Brown is one, Roe v. Wade, which legalized abortion in the United States, is another decision that was influenced. Obergefell v. Hodges was the decision that legalized same-sex marriage in the United States. And so those unique symbolic cases are looked at by other nations, and they even cite our decisions. They say, hey, the United States Supreme Court did this, so we should do it too. And it gets you access to international advantages. Because one of the problems on a domestic topic is you have to debate disadvantages like the politics disadvantage, which have international implications. So someone might run the infrastructure politics disad, and they might say that, hey, Biden's infrastructure initiative is needed to change clean energy in the United States and solve warming, or it's key to the US economy, and that has international implications. And you might be stuck with just domestic implications, which don't have as big of an impact. But if you claim a modeling advantage, you can claim to solve for something in other nations. You can claim to solve for it in developing nations. You might be able to claim to solve for it between the water disputes between Israel and the Palestinians. You might say that you solve for water problems between India and Pakistan. Those kinds of things can give you other kinds of advantages. It can also give you an angle versus the state's counterplan. So you've probably done your research on this topic and realized that the states can do a lot of things. The states are the critical enforcement mechanism of the Clean Water Act. And so you might be worried about the idea that, hey, the states can solve a lot of my advantages. But if you get access to the federal constitution or federal doctrine or the way federal agencies enforce things, then you might have an angle versus the state's counterplan that the state's counterplan can't solve your advantages. You might have influence on other nations via modeling, the unique modeling effect of the Supreme Court, or you might affect all of the federal district courts and their decisions, which the state counterplan can't do. Another reason why I liked to run courts cases when I was a debater is you'll just know more than they do. If you get into the literature about the way courts function and you're really good at debating court shielding and you're really good at debating that courts don't release their decisions until May or June, you'll know a lot more than the other team does. Some people will specialize in politics or economics, and it's actually a good strategy on this topic to specialize in politics, to update your politics disad every week or so, and you might be very good at economics, like you might be very good at debating the inflation disadvantage, or you might be very good at debating the business confidence disadvantage, but you would have an advantage over those teams because you know how the Supreme Court influences politics or economics more than they do. And when they hear your plan, they might go, well, I don't understand your plan. And you, of course, would have the knowledge to explain your plan to the judge, whereas they are at a disadvantage. So I'm briefly going to go over possible Supreme Court cases on this topic, and a very important case on this topic is how the waters of the United States are defined. So in 2015, Barack Obama redefined the waters of the United States to put more waters of the United States under control of the federal government and federal government restrictions. And then Trump came into power and he decided that he didn't like that very much, and he changed that ruling. And now Biden in June has come out and said he's going to revert back to the Obama era ruling. But a lot of people say that there will still be a lot of confusion at the lower level unless the Supreme Court gets involved and defines what the waters of the United States are, what wetlands are protected, what streams are protected, what rivers are protected, etc. And so that can have a lot of impact on water pollution. It can have a lot of impact on what species are protected. And especially if you get into the wetlands debate, you can get into how global warming is solved via this. So I imagine that the waters of the U.S. case will be very popular, and probably the best way to do the waters of the U.S. case is through the Supreme Court. The next thing I can imagine someone doing is claiming a right to water. So some countries like South Africa have said that everyone has a right to water, and the affirmative might declare that either because of international law or because of common law, that everyone in the United States has a right to water. And you could claim international advantages, you could claim bolstering the international right to water if the Supreme Court codified a right to water, especially if they did it under international law. And there are a lot of famous cases in history that people have run that said they incorporate customary international law into their plan. And if they do that, they can bolster international law by acting through the Supreme Court. Another case I've seen is giving indigenous peoples more right to water, and in particular, the United Nations Declaration on the Rights of Indigenous People, or UNDRIP. If the Supreme Court declared that indigenous peoples in the United States had right to water, they could bolster UNDRIP for other peoples around the world, and that would provide more indigenous protections for peoples around the globe, because it's not just the United States that has special obligations to its indigenous peoples, but it's other countries around the globe. So in conclusion, Supreme Court cases are going to be popular on this topic. So I encourage you to increase your knowledge base about these things. Supreme Court cases have unique advantages that you need to be aware of, and Supreme Court cases can give you angles versus disadvantages. So whether you choose to run a Supreme Court case or somebody else does, you're going to need to be prepared. And you'll probably want to listen to my Supreme Court on the negative lecture in case you hear one of those cases and want to be prepared.